Ms Cheyne.
Thank you, Madam Speaker. I present the Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020, together with its explanatory statement.
Clerk.
A bill for an act to amend the Births, Deaths and Marriages Registration Act 1997.
Ms Cheyne.
I move that this bill be agreed in principle.
Question is the bill be agreed to in principle. Ms Cheyne.
Thank you, Madam Speaker. I rise today introducing the Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020. This bill will amend the Births, Deaths and Marriages Registration Act to provide two formal opportunities of recognition that a person was a tissue donor at the written request of a next of kin. Before I go on, Madam Speaker, I wish to clarify that the term tissue under the Transplantation and Anatomy Act 1978 includes organs and tissue. So while I will use...
Clerk.
A bill for an act to amend the Births, Deaths and Marriages Registration Act 1997.
Ms Cheyne.
I move that this bill be agreed in principle.
Question is the bill be agreed to in principle. Ms Cheyne.
Thank you, Madam Speaker. I rise today introducing the Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020. This bill will amend the Births, Deaths and Marriages Registration Act to provide two formal opportunities of recognition that a person was a tissue donor at the written request of a next of kin. Before I go on, Madam Speaker, I wish to clarify that the term tissue under the Transplantation and Anatomy Act 1978 includes organs and tissue. So while I will use organ and tissue donation and organ and tissue donor in this speech today for the purposes of clarity, for the purposes of the Act, and for anyone reading this bill, tissue is technically the encompassing.
Ms Cheyne.
I move that this bill be agreed in principle.
Question is the bill be agreed to in principle. Ms Cheyne.
Thank you, Madam Speaker. I rise today introducing the Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020. This bill will amend the Births, Deaths and Marriages Registration Act to provide two formal opportunities of recognition that a person was a tissue donor at the written request of a next of kin. Before I go on, Madam Speaker, I wish to clarify that the term tissue under the Transplantation and Anatomy Act 1978 includes organs and tissue. So while I will use organ and tissue donation and organ and tissue donor in this speech today for the purposes of clarity, for the purposes of the Act, and for anyone reading this bill, tissue is technically the encompassing term. Madam Speaker, at any one time, there are around 1,400 Australians waitlisted for an organ or tissue transplant. Many more still aren't yet waitlisted, but would benefit from a transplant. But the decision to donate organs and tissue can be a difficult one. It can be a difficult decision if you are a living donor, and it can be a difficult decision on the occasion of someone's death, when the decision is ultimately for the family, and where the circumstances which allow for organ and tissue donation usually mean that the death was sudden and unexpected. Of course, being registered on the Organ and Tissue Donor Register helps inform a family of what their loved one's desires are, and I absolutely encourage Australians and ACT residents to register. But ultimately, in each state and territory in Australia, the decision remains one for the family in these circumstances, a decision at a time when they are often in shock and only just beginning their grieving process. What it comes down to, Madam Speaker, is that the decision to donate organs or tissue is the gift of life. Indeed, the decision often provides for gifts, plural, of life, with multiple lives often saved. It is only appropriate then that we as a jurisdiction ensure we are providing opportunities for acknowledgement, for recognition that are commensurate with and reflect the enormity and significance of the decision and the enormity and the significance of the gift. In the ACT, there currently exist a number of avenues for acknowledgement and recognition of the decision and gift of organ donation, as well as opportunities for awareness raising. This includes annual services of remembrance, one of which is being held this coming Saturday. There is also the annual Gift of Life Walk being held next Wednesday and now in its 14th year, an opportunity for awareness raising and commemoration. And there is the Gift of Life Garden at the National Arboretum, a place of quiet reflection in acknowledging and commemorating organ and tissue donation. Madam Speaker, it's been an honour and a privilege to attend these services and walks and to have officially opened the Gift of Life Garden in late 2018. However, Madam Speaker, donor families and advocates here in the ACT and indeed across the country have raised with me that apart from an acknowledgement letter, usually from the hospital via Donate Life, there are few formal, tangible avenues where the significance of the donation is acknowledged. As a result, some families have reported they feel the significant decision and the significant gift of organ donation is under-recognised. So, Madam Speaker, with my very first private member's bill, I am proposing to amend the legislation to go to some way to change that for families, and I do believe this is an Australian first. Madam Speaker, this bill creates a new section 38A in the Births, Deaths and Marriages Registration Act to provide families with two formal opportunities to have the organ or tissue donation of their loved one acknowledged. The first opportunity for recognition is that on request in writing by a next of kin of the deceased person, together with verifying information, the Registrar General must include in the death register a statement that a person was a tissue donor, with tissue being the technical term for organ and tissue. The reason for including this in the death register is that only information that is in the death register can be included on a death certificate issued by the Registrar General. So, on the occasion of the Registrar General entering this information into the death register, families will then be able to apply for a death certificate which reflects that their loved one was a tissue donor. What is verifying information is very deliberately not defined in the bill. This is because what might be information that verifies the donation and the donor may change depending on the time and the nature of the donation, but examples include acknowledgement letters and consent forms. The second opportunity is that as part of the request for death register inclusion, the next of kin has an additional option of requesting a written acknowledgement from the Chief Minister via the Registrar General, provided that they do this in writing and provide their name and address. The notion behind a letter from the Chief Minister is that it is a letter from the leader of the Australian Capital Territory personally acknowledging the significance of the decision and the significance of the gift of the person who had died on behalf of the ACT, no matter whether the donation occurred while the deceased person was living or on the occasion of death. Like the acknowledgement on the death register and then a death certificate, this would be formal, tangible. It would mean that the head of this jurisdiction was not only aware of the decision and the gift, but took the time to acknowledge it formally. Madam Speaker, I need to stress two important aspects of these opportunities for formal acknowledgement. The first is that these opportunities are optional. I absolutely accept that for some families, the acknowledgement they currently receive may well be sufficient. So there is simply no obligation for families to have these acknowledgements occur. They will only come about at the request of the next of kin. The second aspect is that the family does not need to seek to have this recognition at a particular point in time. These opportunities are not time limited. What this bill proposes is that these opportunities for acknowledgement can apply in relation to a deceased person who was a tissue donor and whose death is or is to be registered under this Act. What this means in practice is that the family can make these requests for acknowledgements soon after the death has occurred, but also at a later date if they wish. There is no urgency in having to decide on the acknowledgement. And this provision also means that families in the ACT whose deceased loved one was an organ or tissue donor at a time in the past will, if they wish, be able to have the death register updated to reflect this, and in turn apply for an updated death certificate and seek an acknowledgement letter from the Chief Minister as well. Madam Speaker, by these acknowledgement opportunities being optional, entirely up to the family and not time limited, it gives the family control and agency in deciding if, how and when they wish to have their loved one's donation recognised. It is entirely in the family's hands to decide what is appropriate for them. Madam Speaker, before I go to my concluding remarks, I want to briefly address some technical issues and questions that arise from this bill. The first is the question of privacy and having tissue donor included on the register and in having the Chief Minister receive these details. Through it being the family which makes one or both of the requests and being done voluntarily only, the number of people with whom this information is shared is limited. Access to the death register is also limited to those who have access to it for a significant time period. Second, Madam Speaker, I want to clarify that this bill does not cover body donations for medical purposes. I understand that institutions which receive body donations subscribe to consistent national confidentiality standards, and it appears that including body donations in this bill would require these institutions to step outside these standards, and that would be a longer conversation to have. Third, by the nature of the Act that the bill is amending, the bill does not provide for circumstances where a next of kin only wants to receive an acknowledgement letter from the Chief Minister. The bill provides for the letter where the next of kin has first requested the acknowledgement on the death register. But there is nothing stopping the Chief Minister from establishing his own arrangement whereby he is able to receive requests for an acknowledgement letter only, and this can be done outside legislation and communicated with families. So, Madam Speaker, at the conclusion of this speech, I will be writing to the Chief Minister to ask him to create this arrangement to sit beside this legislation in the event that the legislation passes. And finally, Madam Speaker, the bill does not provide for what might be appropriate in an acknowledgement letter from the Chief Minister. Given the significance of the letter and what it may mean for families, I will also be writing to the Chief Minister seeking that he engage with donor families and other stakeholders on what text might appropriately be included in the letters that are written, so that the significance of the decision and the donation might best be reflected in the most meaningful way. Madam Speaker, there are many people I wish to acknowledge and thank who have all made a contribution in the drafting of this bill, including a number of people who are in the gallery today. Thank you to the many, many families who have spoken to me about this, from advocating to answering my questions to sharing their very personal stories. I acknowledge that there are families here today, including Marjorie and Michael Taylor, the mother and brother of Annette, who was the first organ donor in the ACT at 11 years old. I believe this year will mark 45 years since Marjorie fought for the donation of Annette's kidneys in the absence of any legislation, and it means an enormous amount to have her and Michael here today. To Penny Mitchell, in many ways this is for her. She has doggedly campaigned for organ donation to be recognised on a death certificate, but not in that for years, but not in the ACT, but in Victoria, collecting thousands and thousands of signatures, sitting outside markets and shopping centres. Penny's done an enormous amount in raising the importance of this issue, and she's been very generous with her time on what has been a difficult subject for her, particularly with the frustration of Victoria not having yet made a move on this. To Leanne Campbell, whose story she shared at the inaugural Donor Families Conference last year, which drove home to me how critically important it is that we better support families. To the Gift of Life Board, especially David O'Leary and former member Genevieve Jacobs, who were always available, helpful and encouraging as I put this proposal to them. To Donor Families Australia for their support and encouragement, and especially Professor Holly Northam, who's also here with us today, who absolutely crystallised the importance of the issue for me and has both guided me and been a sounding board, and received and responded to many, many emails and phone calls over quite a long period of time. And to Parliamentary Counsel Mary Toohey, who has expertly navigated and interpreted my instructions on something that seemed simple but was ultimately quite complex. Legislation is hard, Madam Speaker, and I have enormous respect for people who propose bills and especially those who draft them. Finally, thank you to the Chief Minister, who has been enthusiastic in his support for the proposal, which is pleasing because a good deal of it concerns his position. Madam Speaker, I'll conclude with some comments from families who have explained to me exactly what this would mean to them. One family said to me that the donation of organs and tissue is a blend of great sadness and feelings of great hope for the recipients. The provision of a formal mechanism whereby families of donors can be comforted by the inclusion of the donation on the death certificate will add a very positive step in the grieving process. Marjorie said eloquently and simply that it's about putting history in place. For Helen Day, whose son Stuart died in a motorcycle accident in Canberra in the early 2010s, she said that this is so very personal and having the option will mean a lot. Helen said it would show he was able to help people. It's a personal thing and I know it may not be for everyone, but for myself and others, they would find it was helpful to have that acknowledgement. Penny Mitchell said to me, "You don't know what this means to me." And finally, Madam Speaker, there's one particular donor family who I wish to acknowledge who holds a very dear place in my heart. And I'll be frank, they were honest with me that they weren't sure they would take up these opportunities for acknowledgement if they became available. But what they did do, Madam Speaker, is that they stressed to me that it was having the option that mattered. And that's what I'm proposing in this bill, Madam Speaker, options. For some families, these options might not be something they wish to pursue. But for others, having these opportunities for a formal acknowledgement could and would mean the world. I cannot overstate the significance of the decision to donate organs and tissue, let alone the significance of the gifts themselves. It is simply the right thing to do by these families, the right thing to do by these donors, to have more formal acknowledgement opportunities to reflect and emphasise the significance of these gifts of life. I commend the bill to the Assembly.
Question is that the bill be agreed to in principle. Mr Barr.
I move that debate be adjourned.
Question is the debate be adjourned. Those of that opinion say aye. To the contrary, no. The ayes have it. The question now is the resumption of debate be made on order of the day for the next sitting. Those of that opinion say aye. To the contrary, no. The ayes have it. Thank you, members. Clerk.
Order day number 1, Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020. Resumption debate on the question that this bill be agreed to in principle.
The question is that this bill be agreed to in principle. Mr Barr.
Thank you, Madam Speaker. I was being courteous in letting the opposition respond first, but they're obviously not ready to or going to, so I will speak now. So I thank Ms Cheyne for bringing the bill before the Assembly, a bill that amends the Births, Deaths and Marriages Registration Act to ensure families of organ and tissue donors can seek formal recognition of their loved one's life-saving gift. Ms Cheyne has previously outlined this bill will allow a next of kin to request in writing with verifying information that the ACT Registrar General include in the death register a statement that their loved one was a tissue donor. By doing so, a family can then apply for a death certificate that recognises their loved one as a tissue donor. Madam Speaker, I understand for many families the formal acknowledgement of their loved one's tissue donation will be significant, but it might not be for everyone. Like organ and tissue donation itself, this decision is of course a deeply personal one. That is why it's important that this process is entirely optional, and it's also important that the process is not time sensitive. Some next of kin may wish to make a written request soon after their loved one has died. Some families may not be ready and may wish to do so at a later date. Others may not be sure. There will be no deadline for when a written request can be made. This also allows a next of kin to seek formal acknowledgement of a loved one's donation, even if it occurred before this legislation comes into effect. This bill, Madam Speaker, ensures every donor family has agency in deciding if, how and when they wish to recognise their loved one's donation. I also want to highlight my commitment to responding to any requests, Madam Speaker, for a letter on behalf of the ACT that acknowledges the significance of an individual's organ or tissue donation. I understand that this will not form part of the legislation. However, we will ensure there is a process in place to respond to any requests for an acknowledgement letter as soon as possible. In doing so, we will work with donor families on appropriate wording for these letters, as it is important that we get this right. So, Madam Speaker, I again thank Ms Cheyne for this bill and commend it to the Assembly.
The question is that the bill be agreed to in principle. Mr Hanson.
Madam Speaker, thank you, and I'm pleased to say that the Canberra Liberals will be supporting Ms Cheyne's private member's bill, and just to highlight that it is a private member's bill, and Mr Barr wondered why he was resuming debate. That's because he adjourned this legislation, and it is customary if the government adjourns a bill that is from a Labor backbencher, then they resume debate, not the opposition. I expected you to recall that, Mr Barr, but nonetheless. Look, this is a short bill, but no doubt for some people this will make a big difference. It'll provide for the official recognition of the gift of life from an organ or tissue donor. Often that gift grants life to more than just one person, Madam Assistant Speaker, and it's a gift that can be provided in no other way. It's often made at a time of extreme emotion. It's also a gift that currently has no official forum for recognition. And this bill will do that. It holds it on request by a next of kin. The official registrar will include a statement that recognises and acknowledges that gift. As Ms Cheyne's acknowledged in her presentation speech, the bill does not cover every single aspect of this complex and difficult matter, but it does provide a formal recognition for those families who chose this way to commemorate the gift their loved one has provided. It's also, as a matter, when drafting a bill like this, it has led to some amendments that are coming forward from the government, and I can indicate that we will be supporting those amendments as well. And they include a delay to ensure the systems are in place to operate properly, a clarification of definitions and removing a clause about receiving a letter from the Chief Minister, as I believe that can be done administratively and not necessarily through legislation. As I said, we acknowledge the gift that's given in these circumstances. I think that this is an appropriate way to recognise that gift that is made. I thank Ms Cheyne for bringing this forward. I think all of us in this place recognise and acknowledge the significant thing that is done when a loved one makes a donation. It's a difficult time, and if this goes some way to helping and acknowledging the contribution that has been made by those individuals, then I think that's a good thing, and I am very pleased to support this legislation.
The question is that the bill be agreed to. Mr Rattenbury.
Thank you, Madam Assistant Speaker. This bill provides important recognition of the priceless gift made by tissue donors in our ACT community. For many family members, the knowledge that their loved one was able to help others to live full and happy lives can give meaning to an untimely and tragic death. The ability to receive formal recognition of this contribution can be hugely important, both to grieving families and to our community, to express our gratitude for this gift and to raise the profile and support for tissue donation. The government is supporting the bill, with some amendments to ensure that it can be implemented appropriately. The bill allows families of tissue donors to apply for a new death certificate from the Registrar General of Births, Deaths and Marriages, which specifically recognises that the deceased was a tissue donor. The bill would also allow the families to ask for a letter of acknowledgement from the Chief Minister. When presenting the bill, Ms Cheyne noted that not all donor families will want this formal recognition, but for those who do, a death certificate and a letter of acknowledgement will have real significance and meaning. The government strongly supports the intent of this bill. The amendments which follow are made to reduce the complexity of the bill to avoid unintended impacts and to allow it to be successfully implemented. Firstly, the amendments would refine the definition of tissue donor for the purpose of the bill, so the amendments will apply to deceased tissue donations and not extend to living tissue donations made during the person's lifetime. This amendment is necessary to address the complex nature of tracing living tissue donations. A particular complexity of living donations is the scope and number of these donations, which can include byproducts of joint replacement, surgeries such as hip or knee replacements. In 2019, this form of tissue donation constitutes about 90% of all living tissue donations in Australia. During a donor's lifetime, tissue donations may have been made at a place outside of the ACT or even outside of Australia. Significant time may have passed between the tissue donation and the registration of the donor's death in the ACT. The scope and timing of living donations create a range of difficulties for the Registrar General in verifying these donations. Nationally, there were 3,504 living tissue donations in 2019 alone, compared to 548 deceased tissue donations. Another obstacle in accurately identifying living donations is that states and territories have inconsistent interpretations of the term tissue, with some jurisdictions having very broad definitions, which would include breast milk donation, while others have much narrower definitions. While the government acknowledges that living tissue donations are also altruistic and worthy of recognition, these donations are not so intimately connected with the death of an individual. It is not consistent with the functions of the Registrar General to record health information across a person's lifetime in a register entry relating to death. Limiting the operation of the bill to deceased tissue donation would make verification of donations more straightforward and preserve the integrity of the register. A death is registered in the ACT if it occurs in the ACT. For all deceased tissue donations in the ACT, I understand the donor's next of kin will receive an acknowledgement letter from Donate Life, which may be provided to the Registrar General as evidence of the deceased donor status. Madam Assistant Speaker, the second amendment the government is moving will remove from the bill the process of obtaining a letter of acknowledgement from the Chief Minister. While the government supports this policy and the Chief Minister has just indicated his personal commitment to it, and the government is committed to it, we believe this can be better implemented as an administrative process through the Chief Minister's office, which does not require the involvement of the Registrar General. It is important to note that a letter of acknowledgement and a change to the register recording deaths are two distinct processes and need not necessarily be linked. It may be important to a family to have a letter from the Chief Minister, but they may not wish to change the register entry. These families need not have to go through an additional step. A direct request would also avoid potential privacy issues in sharing this information and facilitate the sensitive handling of confidential health information. Finally, the government amendments would delay the commencement of the bill for a maximum of 12 months to allow Access Canberra to make necessary changes to its operations before accepting applications. The families of donors deserve an application process that is carefully designed and accords appropriate dignity to the deceased. The government is grateful to Ms Cheyne for her contribution in her first private member's bill and appreciates the significance of the subject matter the bill is addressing. Tissue donors and their families make an invaluable contribution to our community, and it is appropriate that this contribution is recognised and honoured. I think this is a moment to reflect on also the regular message we receive to encourage more Canberrans to sign up as donors if they feel personally comfortable with that, because each donation can make a very significant impact in somebody else's life. The government, and on behalf of the Greens for myself, support this bill, and I'll be moving the amendments shortly in the detail stage of the debate.
The question is that the amendment to Ms Cheyne's bill be agreed to. Ms Stevens-Smith.
Thank you, Madam Assistant Speaker. I rise today in support of Ms Cheyne's private member's bill seeking to amend the Births, Deaths and Marriages Registration Act 1997. And in rising to support the bill, I'd also like to acknowledge the energy and commitment that Ms Cheyne makes in organ and tissue donation policy space. Ms Cheyne has been a passionate advocate and supporter of increasing the rates of organ and tissue donation, and regularly raises the issue with me in my capacity as Minister for Health, as well as through her prolific social media and public presence. The Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020 is further evidence of Ms Cheyne's commitment to this policy area, and is based on her extensive engagement and consultation with the families and friends of organ and tissue donors. Donating an organ or tissue is gifting someone another chance to be with their family and to continue contributing to society. It can change a life, or it can save a life. In recognition of the importance of organ donation, Australian governments have been working collaboratively to endeavour to increase registrations on the Organ Donor Register. Since 2009, there has been a doubling of organ donation registration and almost twice as many people receiving transplants. This collaborative effort and focus by all governments has driven increased registration on the Organ Donation Register and resultantly in donations. The ACT government actively participates in the national program to increase the donation registration through the Organ and Tissue Authority. Locally, we also support Gift of Life, which, among many other worthy activities, organises the annual Donate Life Walk. Earlier this year, on the 26th of February, Ms Cheyne and I joined around 2,000 other Canberrans, back in the day when you could join 2,000 other Canberrans, on the 14th annual Donate Life Walk to raise awareness of organ donation. I am pleased that the ACT government continues to support the Gift of Life's important work getting the message out to people and to the community, and promoting the Australian Organ Donor Register. When we were able to gather again, I would encourage all members to attend the next Donate Life Walk. It is a powerful reminder of the importance of registering for organ donations. I also encourage all members to consider registering as an organ donor if you haven't already done so, and to have a conversation with your family and friends. As the Gift of Life slogan states, have the chat that saves lives. We know that when donation is possible, the main reason families decline for donation to proceed is because they were unsure of the wishes of their loved one. We need more Canberrans to talk about organ and tissue donation with their family, and to register their donation decision on the Australian Organ Donation Register. Increasing organ donation registration is critical because less than only 2% of people who die in hospital can donate an organ. Increasing the number of people registered to donate increases the likelihood of saving lives. Madam Assistant Speaker, since 2009 there have been 133 organ donors in the ACT. In 2019, the ACT had 10 organ donors, resulting in life-saving transplants for 32 Australians. Nationally, over the past 11 years, more than 13,000 Australians have received an organ transplant, thanks to the generosity of more than 4,500 donors. However, at any given time across Australia, there are around 1,600 Australians on transplant waiting lists and a further 12,000 people on dialysis. There is more to do. Madam Assistant Speaker, in 2019 there were 554 deceased donors across Australia. Their lasting contributions should be recognised, and the donor's family afforded the affirmation that their mother, father, brother or sister, son or daughter saved countless others. The bill before the Assembly would amend the Act to allow the next of kin the option to request formal acknowledgement of the deceased donation of organs and tissue on the death register. This proposed amendment provides an additional avenue for the family and loved ones of the deceased to honour and recognise the deceased for their generosity. The proposed amendment to the Act may provide further comfort to family and friends, which we know is critical to increasing our organ donation rates across the country. And it provides another avenue for the community to formally recognise the gift provided. Madam Speaker, any change that can support families and recognise the individual's contribution to society is worthwhile. And I acknowledge the amendments that have been foreshadowed by Minister Rattenbury, which of course we will be supporting, and I understand Ms Cheyne is also supporting, that will remove the recognition by the Chief Minister from legislation and make that an administrative process. But again, I think the fact that Ms Cheyne thought this through, that would be an appropriate acknowledgement for families to have a letter from the Chief Minister through whatever process is most convenient and appropriate for families, I think is a really important move forward for families of organ donors, but also reflects that Ms Cheyne cares deeply about these issues and has worked really hard to engage with families about what is going to work for them. So I thank Ms Cheyne for bringing this bill to the Assembly, and I commend it to the Chamber.
The question is that Ms Cheyne's bill be agreed. Ms Cheyne.
Thank you. In closing.
Sorry, Ms Cheyne. Sorry. That you agree that the bill be agreed to in principle. Ms Cheyne.
Yes, thank you,
Sorry,
Madam
came in at the last minute and got all confused.
Thank you, Madam Assistant Speaker. And yes, this is in closing to the in principle debate. Madam Assistant Speaker, acknowledging organ and tissue donation on a death certificate may seem like a simple gesture, but for some families whose loved ones in death gave the ultimate gift, this simple gesture will mean the world. When I introduced the mouthful bill, Births, Deaths and Marriages Registration Tissue Donor Acknowledgement Amendment Bill 2020 earlier this year, I briefly spoke about Helen Day. You might recall that Helen's son Stuart tragically died in a motorcycle accident in Canberra in 2012, 4 days shy of his 24th birthday. It's every parent's worst nightmare, losing a child. Stuart's death was sudden and unexpected. Amid the shock and grief, Helen, as Stuart's next of kin, needed to make a significant decision, whether to consent to Stuart's organs and tissue being donated to others. Because ultimately, it is the family left behind that makes this decision, one that has the power to change numerous lives. Helen knew Stuart would have wanted to be a donor, and so she provided her consent. In death, Stuart went on to save 6 lives. Helen wants Stuart to be remembered as a man who gave back in life and in death. It would mean so much to her to have greater acknowledgement of her son's legacy. And she is not alone. Madam Assistant Speaker, many donor families and advocates in the ACT, but right across Australia, have told me that there are few tangible opportunities to formally acknowledge the significance of organ and tissue donation, that the significance of the gift for some families is under-recognised. This bill proposes amendments that would give families like Helen's an avenue to gain greater recognition of their loved one's donation, if they wish, if it is right for them. The bill is primarily about families having the option to have that their loved one was a tissue donor included on their loved one's death certificate. Why is including it on a death certificate so important? It's not just because it's a permanent record. It's also because a death certificate is, in some ways, the formal summation of someone's life. It can contain the vital statistics about a person. It follows then that it should accurately reflect their final, most generous act. Three principles have guided me throughout the approach I've taken to this: that the opportunity to have this recognition on the death certificate be optional, entirely up to the family, and not time limited. My aim has been to give each family control and agency in deciding if, how and when they wish to have their loved one's donation recognised. I believe the bill achieves this. As has been flagged, the government is proposing 3 amendments, each of which I support. I do not intend to speak to them in the detail stage, so I will address each of them briefly now. One is to delay the start date by a maximum 12 months. While I would like what is in this bill to begin immediately, I do appreciate that there is a bit of work behind the scenes in the Directorate and with the Registrar General to give effect to the legislation, ensuring the practicalities behind making sure the process of requesting that the acknowledgement be recorded are as smooth as possible. That's really important to get right. This needs to be as straightforward as possible for families and not overly bureaucratic. So I'm happy to support this amendment so that we can get it right. That said, I will be frustrated and I will be knocking on the Minister's door if it does take a full 12 months for this to be carried out. So while I accept the amendment, I do hope it is much sooner than within 12 months' time. The second amendment that's been proposed removes the legislative provision regarding the family being able to request through the Registrar General a letter of acknowledgement from the Chief Minister. As Minister Rattenbury has flagged, this is something that does not need to be a legislative provision. It can be done through an administrative change with the Chief Minister and his office and directorate, and it will be simpler if the request is direct rather than linked to the Registrar General. And importantly, in doing so, it allows people to request the letter whether they wish to have the acknowledgement on the death certificate or not. So it separates those two processes. I don't want to have something in legislation simply for the sake of it. So on the basis that the Chief Minister has been clear in his support of this and that this is something that he will do, I accept that this does not need to be provided for in the legislation. I acknowledge his commitment today that he will work with donor families and the broader network on what the most appropriate and acceptable form or forms of words may be for this acknowledgement letter. Madam Assistant Speaker, the third amendment relates to the definition of tissue donor and thus who will be eligible to have tissue donor recorded on the register and on their death certificate. In this case, the amendment will provide only for those who donate organs or tissues on the occasion of their death. In agreeing to this amendment, I acknowledge that the heart of the intent of the legislation has been kept and appreciate the lengths to which Minister Rattenbury has explained in his speech the issues around including living tissue donation at this stage. Madam Assistant Speaker, what isn't changing is that the opportunity for recognition on a death certificate remains optional, entirely up to the family and not time limited. Families will be able to make the written request at any time, but it is a matter for each family to decide for themselves if it's something that works for them. This removes any urgency in needing to make a decision about it, and it takes into account that what might be right for each family can change over time. It also means that families whose deceased loved one was an organ or tissue donor before this comes into effect will have this opportunity too. Families like Helen Day and so many others. Madam Assistant Speaker, this is, to the best of our collective knowledge, an Australian first. However, ACT residents are not the first to push for it. This is a national issue for donor families who wish to have this option. And I again want to acknowledge the incredible work of so many, but especially Penny Mitchell in Victoria, who after 10 years of effort, sitting outside shopping centres, farmers markets, getting handfuls of signatures at a time on her petition, until she got thousands and thousands, a tedious process, but such an important one, who got the Victorian government to sit up and pay attention to what she hoped to achieve. But, Madam Assistant Speaker, in Victoria it fell over, I believe, because that government looked at it too narrowly. There are genuine issues relating to the very strict privacy of health records and the obligations of health professionals in managing those records, particularly as they relate to organ donation. And I understand why the Victorian government was apprehensive about pursuing this, and indeed believed they couldn't. However, with a bit of lateral thinking, and with the support of donor families and the drafting office, I've been able to approach this from another angle. By the agency behind this resting entirely with the family, the issue that halted Victoria's consideration has, I believe, been avoided. I really do want to thank all of those who have viewed and reviewed and scrutinised the bill in the spirit that it was intended, including those who have had to consider it from a public policy and implementation perspective, and the practical lens that has been applied at each stage. It's because of this collective attitude that we are making history in the ACT today. And I know donor families right across the country, like Penny, are hopeful that this legislation might serve as a template for other states and territories to follow suit. Madam Assistant Speaker, I've been overwhelmed with the generosity of families, advocates and experts who have shared their expertise, knowledge, and in some cases, their very, very personal experiences with me. Again, my thanks to Penny Mitchell, Leanne Campbell, Marjorie and Michael Taylor, Helen Day, Mel Bezier, and others. My thanks to the Gift of Life Board, especially David O'Leary and former member Genevieve Jacobs. To Donor Families Australia, especially Bruce McDowell and Professor Holly Northam, who was unfailingly generous and responsive with her time and expertise. Mary Toohey and the Scrutiny Committee. As I said in my presentation speech, legislation is hard, and this has been drafted with a very, very small team. We are grateful to have had the expertise provided by the Drafting Office and the Scrutiny Committee. To Minister Rattenbury and his office and the directorate that sit behind them, who have worked on providing these very sensible amendments, my sincere thanks. To the Chief Minister and his office, the Health Minister and her office for their support right from the outset when I first came knocking on their door well over 6 months ago. Thank you very much to the opposition for their support and again the openness with which they've approached this. Thank you to my colleagues for the priority it has been given in being able to debate it and, it seems, pass it today. To my superb staff, Emma, Nick and Gemma, you know how much work you do and how much that means to me. And to all those who have recognised that this is good legislation worth supporting. Madam Assistant Speaker, it's an honour to bring forward my first piece of legislation in this place on an issue I'm so passionate about that has tripartisan support and which will be an Australian first. But the greatest honour has been to give a voice to Australian donor families in this place. For the donor families, this is for you. But most importantly, this is for the donors, past and future, who you love so much and to whom we, as individuals and as a society, owe so much. I commend the bill and the proposed amendments to the Assembly.
The question is that the bill be agreed to in principle. Those of that opinion say aye. The contrary, no. I declare the ayes have it. Is it the wish of the Assembly to dispense with the detail stage? Is it the wish of the Assembly to take the bill as a whole? The question is that the bill as a whole be agreed to. Mr Rattenbury?
Thank you, Madam Assistant Speaker. I seek leave to move amendments numbers 1 to 3 circulated in my name together.
Is leave granted? Mr Rattenbury?
Thank you, colleagues. I move amendments numbers 1 to 3 circulated in my name together, and I also table a supplementary explanatory statement to the amendments.
The question is that Mr Rattenbury's amendments numbers 1 to 3 be agreed. Mr Rattenbury, no? Those of that opinion say aye. Contrary, no. I declare the ayes have it. The question is now that the bill as amended be agreed to. Those of that opinion say aye. On the contrary, no. The bill as a whole is amended. The question is that the bill as amended be agreed to. Those of that opinion say aye. The contrary, no. I declare the ayes have it.